Senator Kroom, whenever you're ready, go ahead and describe your bill.
Thank you, Mr. Chair, members of the committee. Here today on Senate File 3579, which is a Bar Association bill. This bill addresses the different levels of jurisdiction that courts have in trust-related cases. For the committee's benefit, provides two ways to exercise jurisdiction in personam, which allows a court to exercise control over the parties who have an interest in a trust. This means the outcome of the case is binding on all the parties who are properly served. And then there's also what's called in rem jurisdiction, which refers to a court's authority over the trust property itself. This means the outcome of the case is binding on the trust itself and resolves anyone's claims with respect to the trust or trust property. Mr. Chair, this is a pretty simple bill. It seeks to clarify a recent Court of Appeals decision, Swanson versus Wolf, which looked at some changes that were made in 2016 that the legislature made to bring our trust laws more towards the uniform laws. And there was that Court of Appeals case caused some confusion. Really what this bill does is to seek to clarify that the statute so the courts can operate with maximum efficiency and parties aren't forced to pay unnecessary fees. Really, it's to make it clear that the practitioner has two different ways, two options here, in personam or in rem jurisdiction, which is basically, the in rem is how they've been operating for a century. So that's kind of the summary of it. To testify on how this bill would fix that confusion, joining me today is John Worrell, who's a practicing trust attorney from South St. Paul.
Mr. Worrell, welcome to the committee. Go ahead and state your name and provide us with your testimony.
Thank you, Mr. Chairman. John Worrell, W-O-R-R-E-L-L. I'm here representing the Probate and Trust Law section of the Bar Association. I'm a 1995 magna cum laude graduate of William Mitchell and a lifelong resident of the state of Minnesota. My practice focus for the last 15 years has been in the probate trust arena, dealing with both litigation as well as non-litigation, and helping folks out both plan for when a loved one dies or dealing with circumstances after a loved one has passed away. The law gives the court the power to decide lots of things when we talk about trusts. Some examples are whether a trustee should be removed, or approval of trustee accounts, or interpretation of what trust terms mean. In each case, on whatever the issue is that a court is being asked to make a decision on, the proceeding can happen in one of two ways. The party bringing the case can invoke either one of these two according to the new trust code that took effect in 2016. It's not something a court decides. This bill clarifies that court cases about trusts can be decided either way, with in personam or in rem jurisdiction. So when we talk about in personam, this simply means that notice of the proceedings are given to persons personally. They have to be personally served, much like a civil lawsuit. When we talk about in rem, which is what all trust proceedings in Minnesota were until 2016, in rem jurisdiction is obtained primarily by mailing notice to all of the persons interested in that particular trust and publishing notice in a legal newspaper for 1 week. And by doing those two things, the court is able to obtain in rem jurisdiction. So the committee can understand that compared to trying to serve 10, 20, 30, 40 people with a process server for in personam versus simply mailing out notices to those same people and publishing in a legal newspaper for 2 weeks, for 1 week rather, to get in rem jurisdiction, that makes a whole lot more sense and saves a great deal of costs, because these actions are oftentimes brought by trust beneficiaries that either don't think the trustee is doing the right thing or have questions or asking the court to interpret terms of the trust. So in 2016, we created and updated our trust code to provide an alternative option, this in personam option. The intent was to add a second option while maintaining in rem. And the Swanson case basically looked at the law and said, no, if you want to remove a trustee, you cannot do that in rem jurisdiction. If you want to remove a trustee, that has to be in personam jurisdiction. And that is not what the intent was of the Bar Association that spent literally hundreds of hours preparing the new trust code that was enacted by the legislature in 2015 and then became effective in 2016. Basically, the Court of Appeals in Swanson found that the 2016 statute, instead of adding an option, actually replaced our 100-year-old option of proceeding on an in rem jurisdiction basis. So the proposal simply clarifies that in rem jurisdiction, our method in place for more than 100 years, is the same as it's always been. We add the in personam at the option of the person bringing the case, but they also have in rem available. Making this clear will simply more efficiently use the court system and save money for the parties by being able to continue to elect in rem jurisdiction if that's how they would like to proceed. I'd be happy to answer any questions.
Thank you, Mr. Worrell. Any questions? Senator Howe.
Thank you, Mr. Chair, and sir, could you explain to me, I just don't normally see where we go retroactive for 8 years, and is that gonna create an issue, or does it solve issues? But going retroactive 8 years seems to be quite a big step.
Mr. Worrell, Senator Kroon.
Thank you, Mr. Chair.
Senator Kroon.
Senator Howe. I'll turn it over to Mr. Worrell here in a second, but actually what this retroactivity clause is gonna actually help quite a bit, because there's a lot of pending trusts out there. And it really, in a sense, that was the intent of the Bar Association and effectively the intent of the legislature back when this was changed, and it's how people have been, practitioners have been operating. If we don't make it retroactive, it's actually gonna create new problems down the road. But to supplement that answer, I'll turn it over to Mr. Worrell.
Mr.
Worrell.
Chair, Senator, it is intended to solve problems, to remove the uncertainty. Because as a practitioner, if you tell me that this bill is effective on August 1st, what is the effect of that bill for litigation that's already been started? It creates more uncertainty. The other part of the retroactivity is to make clear that there were supposed to be two options at all times. The Swanson case took one of the 24 potential causes of action that are in our trust code and said for that particular cause of action, you have to go in personam. Well, if we don't make it retroactive, there is always the possibility that in the meantime, some other cases have started, and now we've got a case that's going on that was one of the other 23 trust actions, and that trial judge says, well, no, this should have been in personam. And so the retroactivity is designed to tell the court system and the trust practitioners that from the start, there were supposed to be two options. And either one of those options are good for any one of these 24 actions that are found in the trust code.
Any further questions? Any discussion? Anyone else in the room want to testify on this bill? I think we have the only expert in the room on the topic, right at the testifier table. Although Senator Westland is having, not the only lawyer in the room, probably having PTSD from law school classes on the topic. Senator Kroon, I think this bill goes to the floor from here, so without any further conversation, Senator Kroon moves that Senate File 3579 be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Kroon.
All right, I'll call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 7th, 2024. We do have a quorum. The first item on the agenda is approval of the minutes from March 5th. Do I have a motion?
So moved.
Representative Feist moves the minutes of March 5th. Any discussion? All those in favor, please say aye. Aye. Opposed? Motion prevails. The minutes are approved. We will get right to it. I did see Representative Agbaje here. I will move to recommend that House File 3589 be placed on the general register. Welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair and members of the committee. I'm here to present House File 3589, which seeks to clarify jurisdiction in trust cases. The bill allows for two options for jurisdiction in cases involving trusts. While the law as written should already allow this, there has been recent confusion as to whether the jurisdiction would only apply to actual persons or to the trust itself. In 2023, the Minnesota Court of Appeals decided that the law, as it is currently written, only applied to the actual person and not the trust property for the types of cases listed. Since that was not the intention of the advocates of the law in 2016, we bring this bill now to clarify that jurisdiction in trust cases can apply either to a person or to the trust. Both options would now be available to litigants. And by clarifying this law, it would cut down on unnecessary pleadings and paperwork for clients and extra work for the district courts. So with that, I'll turn it to my testifier who can explain further.
All right, welcome to the committee. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. My name is John Worrell. I'm a practicing attorney here representing the probate and trust law section of the Minnesota Bar Association. Minnesota trust law gives the courts power to decide many things about trusts. Some examples are whether or not a trustee should be removed, whether or not a trustee's account should be approved, or interpretation of what trust terms mean. In each case, on whatever the issue is before the court, the proceeding can happen in one of two ways under current law. The party bringing the case makes the decision as to which of these two ways they want to invoke the jurisdiction of the court. It is not something that the court decides. The bill clarifies that court cases about trust can be divided in either in rem or in personam jurisdiction. In personam very simply means that notice will be given freely to each party who's involved in the trust. Very similar to a civil lawsuit where a process server or a sheriff has to go out and put a piece of paper in somebody's hands. The way that we have done it for 100 years before the trust code was amended in 2015 and became effective in 2016 is what we call in rem jurisdiction. And this means that notice is done in one of two ways: mailing by first-class mail and publishing in a legal newspaper for 2 weeks. So you can see that in rem jurisdiction is far easier and far less expensive because it does not involve personal service of 10, 20, 30, 40 people that might be involved in a trust. The amendments to the trust code and updating our trust code in 2016 were done to offer an option, an alternative in personam. It was not intended to make the courts describe or decide which piece of jurisdiction should apply to a particular case. And this Court of Appeals case called Swanson, that's exactly what happened. The Court of Appeals in Swanson said, if you want to remove a trustee, you must proceed in personam. And that was simply not the intent of the Bar Association and hundreds of hours of lawyers who practice in this area to put together the updates to the probate, or the trust code rather. So our proposal simply clarifies that in rem jurisdiction that has been the rule of law in Minnesota for more than 100 years remains the same. The 2016 updates to the code simply add a second option that the participants in the trust case, bringing the trust case, can choose, either in rem or in personam. Making this clear will be more efficiently use the court, and more importantly, for those that need to use the court, trust beneficiaries significantly reduce the cost because they will be able to proceed with confidence that in rem jurisdiction will allow them to see their case to conclusion. I'd be happy to answer any questions.
All right, are there any other members of the public wishing to testify on this bill? All right, we'll move on to committee discussion. Representative Niska.
Thank you, Chair Becker-Finn. Thank you, Representative Agbaje. Did I say that right?
Yeah.
Yes, okay, all right. For your patience, first of all, in coming back and your work on this. Thank you to the State Bar Association section for your work on this. This is an important part of the conversation we have among branches here. Sometimes we say things that aren't completely clear, or sometimes the courts make mistakes, and I don't think it's important that we figure out what happened in the past. And on this particular question, I think it's good that we're working to clarify it. So I appreciate the work that's being done. I was hoping that Mr. Worrell, maybe you could help just everyone to understand a little bit, what are the reasons why it might be necessary to choose one option over the other? Why is it important to have both options? And just in case this is helpful to anyone who didn't go to law school or doesn't know the Latin, in rem means jurisdiction like over a thing, in this case a trust. In persona means jurisdiction over people. I think you explained that pretty well, but just in case that, I mean, that might be helpful, I think, for some people to kind of put that last piece together. But if you could just help us to help people understand why would we want both options? Why would one option be chosen over another?
Mr. Worrell.
Madam Chair, Representative, two answers to the question. The updates that were done to create what is today the Minnesota Trust Code were done primarily to come into conformance with the Uniform Trust Code and the uniform laws. And the uniform laws use in personam jurisdiction primarily. So there was a great deal of discussion as the bill was being drafted as to should we just simply stay with what Minnesota has done for 100 years, or should we add in this option? And the decision came, let's add in the option because it's an option. And so the thinking was, we'll still be able to choose. The answer in terms of when you would use it, what we came up with, and again, discussions 5-6 years ago, was in persona might be appropriate where you have a real private trust or perhaps involving very public figures. Because as we talked about, in rem jurisdiction, in order to get court jurisdiction, you have to publish in a legal newspaper. And believe it or not, there are a lot of people that actually read that. And if they see the Dayton Trust is coming up for a trial or some trust action, they may be very interested in that. On the other hand, if all the members of the Dayton Trust want to keep that a bit more under the radar, now again, court proceedings are also public information, but it's not published. So you could literally start that action, and unless somebody picked up the court filing, basically going in personam, serving everybody but not publishing, would allow you to proceed with some level of less publicity. And that's the only thing that we were able to come up with as to an advantage of in personam. Everything else we came up with were basically detriments.
Representative Niska.
Thank you, Chair Becker-Finn. Thank you for that very good explanation. Like I said, this is a good bill. It helps to clarify the statutory language, and hopefully, to the extent there is still any questions as this goes forward, your testimony here will be helpful as well to clarify the history of it. So, thank you again for your work. Thank you, Representative Agbaje, for your work on this as well. And I urge members to vote yes. It's a good bill.
All right.